Good day, class. This is part 3 of my Criminal Law Book 1 recorded lecture. So, we'll tackle Article 4 and Article 5 today. So, Article 4, Criminal Liability. So, who will incur criminal liability? So, under Article 4 of the Revised Penal Code, criminal liability shall be incurred by any person committing a what? A felony. What's a felony or delito again? A felony is an act or omission punishable by the revised penal code. Examples: homicide, murder, infanticide, parricide, okay, theft, robbery. Uh, although the wrongful act done be different from that which he intended. So one good example of this is mistake in identity or error in personae. This is say A shot B, okay, not knowing that it was C. Okay, si C na ito, he thought it was B, but iyang napatay is C. So that's mistake in identity or error in personae. Or aberratio ictus or mistake in the blow. So si A, iyang gipatay si, ganun yung patin si C. So he fired a gun, but as a result, due to poor aim, si B mo yung naigo. Okay, so that's aberratio ictus, okay, or mistake in the blow. So what's the difference between error in personae and aberratio ictus? In error in personae, the victim, okay, was mistakenly identified as the actual victim. Okay? In aberratio ictus or mistake in the blow, naa si intended victim. The intended victim is present and the actual victim is present. But due to poor aim, lahi mo na ego instead of the intended victim. So that's aberratio ictus or mistake in the blow. And then we have praeter intentionem, meaning the effect was greater than that intended. Okay? So let's just say, nagsumbagay sila, si A and B nagsumbagay, si A punched B, then B was hit and fell on the ground, and as a result, he suffered what? Hemorrhage and caused his death. Okay? Although si A, ganun niya sumbagan si B, but as a result, okay, natumba, hindi yung ulo sa pavement, which causes that he is liable for the death of B. So A is liable for the death of B. Second paragraph, by any person performing an act which would be an offense against persons. Okay, what are offense against persons? A murder, homicide, or offense against properties, like theft, okay, or robbery, were it not for the inherent impossibility of its accomplishment or on account of employment of inadequate or ineffectual means. So the second paragraph pertains to impossible crime. Okay? So one good example is si A, ganun yung patin si B. So one night, okay, who went to B's house and while B was sleeping, he stabbed B multiple times, not knowing that B was already dead, okay, few hours ago because of a heart attack. So Mr. A is not liable for murder, but of impossible crime of murder. Why? Because B was already dead. So it's impossible for him to kill someone who is already dead. So let's move on. So please take note of this statement. One, who commits an intentional felony. Intentional felony meaning there's deceit or dolo. Okay, it's an intentional felony. And there is what? A deliberate intent. And the act is voluntary. So one who commits an intentional felony is responsible for all the consequences which may naturally and logically result therefrom, whether foreseen or intended or not. So, katong example ganina, nagsumbagay, but as a result, si B, natumba, naigo yung ulo sa pavement, which causes that. Therefore, A is liable for the consequences of his action. Okay? The statement. So any person who creates in another person's mind, an immediate sense of danger, which causes the latter okay, to do something resulting in the latter's injuries is liable for the resulting injuries. Let's just say in a robbery case, okay? Group of robbers may sulod sa kabas. Okay, then they declared hold up. And as a result, hadlok ang mga tao. Okay, they have created in another's mind an immediate sense of danger that maybe they will be killed or or they will be robbed. So as a result, nang ambag in tawon ang mga passengers. And then some passengers died and some passengers sustained serious physical injuries. Now, are the robbers liable for the resulting injuries? The answer is yes, because of this principle. Any person who creates in another person's mind an immediate sense of danger, which causes the latter or the victim to do something, di ba? Nang layat sila, tungkol sa look, okay, resulting in the latter's then nag-result of injuries, is liable for the resulting injuries. Therefore, liable ang robbers. Okay, take note of that. And then the proximate cause doctrine. So proximate cause doctrine states that criminal liability shall be incurred by any person committing what? A felony. Although the wrongful act be different from that which he intended. So what are the elements of proximate cause? So the intending act must be a felonious act. Okay? The person must be committing a felony. And the resulting act is the what? The direct, natural, and logical consequence of the felonious act of the offender. So example, okay? A bus was going to Quezon. Suddenly, four men boarded a bus. Two men seated at front seats and the other two seated at the back. While they were traversing a zigzag portion of the road, the four men stood up and announced a holdup. One passenger was so afraid of the robber as he had previous experience of robbers. He was so afraid that he opened a window and he jumped out of the window. He fell on a cliff and he died. Now, are the robbers liable for the death of the passenger? The answer is yes. Why? Because the robbers, in announcing a holdup, are committing a felonious act, an intentional felony. And the resulting act was a felony. The resulting felony, what was the direct, natural, and logical consequence of the felonious act of the offenders? Were it not for the robbers announcing hold up, there would be no fear on the mind of the passenger. But because of the announcement, there was fear on the mind of the passenger. And by reason of that fear, he made risk that caused his death. So the robbers are liable for robbery with homicide because they are liable for the death of the passengers. Okay? So, what are the three situations wherein a person becomes criminally liable for the resulting felony, although different from that which he intended? So, number one, aberratio ictus. So, that is mistake in the blow in English. Error in persone, that's mistake in identity in English. And then praeter intentionem. Okay, so let's discuss first aberratio ictus. What is aberratio ictus? It is a situation wherein the offender directed a blow at his intended victim. But because of what? Poor aim. The blow landed on another victim. So let's just say, mo na yung intended victim. So iyang posilon, iyang gitirahan. But si mo na igo. O, kanin mo na igo. So therefore, he is liable for the death or injury sustained by C. Okay? So always remember that in aberratio ictus, the intended victim is present. But because of poor aim, ang actual nilan siya sa another victim. But in error in persone, it is a situation wherein the victim actually received the bullet, but he was mistaken to be the intended victim. Always remember that in error in persone, the intended victim was not at the scene of the crime. Napagkamalan lang. Mistake in identity. In aberratio ictus, naa sa scene of the crime si intended victim. But because of poor aim, lain mo yung naigo. Okay? Then praeter intentionem. So praeterintentionem occurs when the consequences went beyond the intention, or when the injurious result is greater than that intended. Imbis if sumbagon ra niya, namatay na noon. Okay, kaya natumba, naigo ang ulo sa pavement, naka-brain hemorrhage. Okay, that's praeterintentionem. You are still liable because logical and natural consequence man to sa imong actions. Therefore, still liable for homicide. So, praeterintentionem is a situation wherein the offender directed a blow at his actual victim. The victim received the blow. However, the injurious result is far greater than what is intended by the victim. Okay? Impossible crime doctrine. Impossible crime is committed by any person performing an act which would be an offense against persons. What are examples of offense against persons or crimes against persons? Murder, homicide, or offense against property or crimes against property. Theft, qualified theft, robbery. Were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means, that the act performed should not constitute a violation of another provision of the RPC, the Revised Penal Code. So there are two kinds of inherent impossibility. Number one, legal, and second is physical. So let's discuss first legal impossibility. So there is legal impossibility when all the intended acts, even if committed, would not have amounted to a crime. Okay, example, X saw his enemy Y lying on a bench. He went to Y and stabbed Y 10 times, not knowing that Y had already been long dead for 2 hours due to a heart attack. Even if X performed all the acts amounting to murder, still murder would not arise, which is a crime against person, because the victim was already dead. He is no longer a person in the eyes of criminal law. Therefore, there is what? Impossible crime. And what we have is legal impossibility. It is legally impossible for a person to kill someone who is already dead. Therefore, the crime he committed is impossible crime of murder. Okay? Physical impossibility. Physical impossibility exists when an extraneous circumstance unknown to the offender prevented the consignation of the crime. Here, there are circumstances unknown to the offender. The inadequate control of the offender which prevented the consignation of the crime. Example, a person placed his hands in the pocket of another person. Intended to get the wallet of said person, but the pocket was empty. Empty. Ay, wali sulod ang pocket. So it is what? An IC or an impossible crime. Why? Because there's an extraneous circumstance unknown to the offender which prevented the consignation of the crime. Ang pocket, may unod, empty man. So therefore, unknown to him, the wallet was not inside his pocket. Therefore, it is an impossible crime because it would have amounted to theft. Okay? A crime against person if na-isolate yung wallet. But wala man. So there's physical impossibility to commit the crime of theft because the pocket was empty. Okay? And then, naapot ay gitawag nga employment of inadequate means. So example, masayon pag na-example. A determined to poison B. He uses small quantity of arsenic by mixing it with the food given to B, believing that the quantity employed by him is sufficient. Okay? But since, in fact, it is not sufficient, B is not killed. Kulang. Inadequate ang quantity sa arsenic na iyang gimix sa food. So the means employed, okay, by the offender by putting a small quantity of poison is inadequate to kill a person. Therefore, it's an impossible crime. Why? Because there is employment of inadequate means. Kulang, small quantity raman. And it will not be adequate to kill a person. Okay? May mamatay ng kulang. Unless if sufficient. Di ba? Kulang man to, insufficient. Next, employment of ineffectual means. Ineffectual meaning wala epekto. So example, again, A tried to kill B by putting in his soap substance. okay, which he thought was arsenic, when in fact it was sugar. So B could not have been killed because the means employed was ineffectual. Wala epekto, okay? Because it's sugar, it's not arsenic. But A showed criminal tendency and hence he should be punished for impossible crime. Okay? So Article 5, duty of the court in connection with the acts which would be repressed, okay, but which are not covered by law, okay, and in cases of excessive penalties. So whenever a court has knowledge of any act which it may deem proper to repress, but dili siya punishable by law, what will the court do? It will render the proper decision. He will acquit because there is no law punishing such an act. But he must report to the chief executive, the president, through the DOJ, the reasons which induce the court to believe that said act should be made the subject of legislation. So in the same way, the court shall submit to the chief executive through the DOJ a statement, such statement as made improper without suspending the execution of sentence, when strict enforcement of the provision of this code would result to and the imposition of a clearly excessive penalty. Let's just say a person is being tried for a crime that carries an excessive penalty. Okay, what will the court do? Of course, he must impose the proper decision. But he must what? Submit a report to the chief executive through the DOJ, a statement without suspending the execution of sentence and taking into consideration the degree of malice and injury caused by the offense. So render the proper decision even if excessive penalty, but submit a report nga. Excessive ra ang penalty, Mr. President. So dapat i-amend ang law, okay? Or change the penalty, i-lower ang penalty. Okay? And take note that there are no common law crimes in the Philippines. Why? Because we are a civil law country. We enact laws to punish acts. Okay? So that would be all. Thank you.